Welcome back to Good Law, Bad Law. This is a first on this program in a number of ways. First of all, I'm calling in from my cell phone from overseas, and I'm talking to my guest who's on her phone from probably 10,000 miles away. My guest also happens to be Susan Freiwald, my very own sister, and an expert, one of the country's leading experts on cell phone technology, internet technology, and privacy. And we're talking about a very important Supreme Court case that just came down, the Carpenter case, and the decision the justices reached that data about our cell phone usage is protected under the Fourth Amendment, and that the government can't simply easily get at that information without first getting a warrant. What are the implications of this? How does this mean the Fourth Amendment should be understood in this new technology that we have? And what does this bode for future disputes involving privacy and things like Facebook, which we've heard a lot about? All of that is the subject of this really important, fascinating episode of Good Law, Bad Law. Stay tuned. My guest today on Good Law, Bad Law is Susan Freiwald. She's one of the leading authorities on privacy and digital data, things like cell phone data. She's the dean of the law school at the University of San Francisco in San Francisco, and she happens to be also my sister. So, first of all, Susan, thank you very much for being on the program.
My pleasure.
This is a first, and a thrill to have you on. I've been waiting for a topic to have you on as guest, and the Supreme Court delivered big time in this case that just came down very, very recently about how we treat cell phone data and the implications for the search and seizure provisions and protections in the Fourth Amendment. So we're going to talk about that, this really historic opinion. But I also like to start with background. So in addition to being my sister, which is a very important qualification, can you give us a bit of background on yourself and just where you went to law school and what you do and what your areas of interest have been academically?
Sure. Well, I think my most important qualification is that I am the sister of Aaron Freiwald. Beyond that, I went to Harvard Law School, and I was actually the classmate of President Barak Obama. And after law school, I went into teaching. I taught at the Wharton School at the University of Pennsylvania for a few years, where I taught undergrads. And then I moved back to San Francisco, where we grew up, and I was on the faculty there for 20 years, teaching privacy law and a class that started out being called cyberspace law, but eventually was called internet law, and then a couple of first-year classes, contracts law and criminal procedure. And my research interest for that whole time has been the intersection of new technologies and law, so both statutory law and Fourth Amendment law as it regulates things like email and cell site location data and the like. And I moved into administration last year as the associate dean and am now the interim dean of the law school.
Well, and you brought up new technology, Susan, and that's a huge part of what we're going to be talking about in this new Supreme Court case called Carpenter. And I noted this and thought this would be a good intro into the subject. It's Chief Justice Roberts who writes the majority opinion in this case, as we'll talk about. And at one point in his opinion, he quotes Justice Brandeis, one of the great Supreme Court justices, who said, "We must make sure that the progress of science does not erode Fourth Amendment protections." So I thought maybe you could start off by just generally getting us into this really important subject by explaining what Justice Brandeis meant by that and how that applies to this very important development the Supreme Court has handed down.
Well, the Brandeis quote comes from a dissent in the Olmstead case back in, I think it was 1927, where the court refused to extend Fourth Amendment protection to wiretaps because they, because for a couple of reasons. One, because they weren't ready to accept that intangibles could be protected by the Fourth Amendment, because the Fourth Amendment protects what's explicitly protected is the home and people and papers and effects. And so none of those listed things sound like intangibles, and of course phone conversations are intangible. And then the other problem was that there was, even at that time, an assumption of risk analysis that if you were on the telephone, you were projecting your call out into the world. And so if someone tapped it, in that case the government, you didn't really have an argument that that was not okay, because you had kind of waived your right to privacy by projecting that call out. And Justice Brandeis said, that's ridiculous, because, we have to recognize that privacy, that the things that we were concerned about at the time of the founding have morphed into new kinds of surveillance methods that also need to be regulated, and that's been a real back and forth with the court and technology about how do you think about moving the Fourth Amendment into the present, actually. And one of the things that's striking about this case is that it took the court so long, actually, to protect cell site location data, because we've been using cell phones now for 20 years. And so in a way, you could say this is a case about new technology, but it's actually kind of old technology at this point.
Well, but it's certainly new compared to, as you say, what the founders talked about and thought about and could even imagine when they came up with the Fourth Amendment. So let's start there. You mentioned intangibles, these things that are not in the express list of those things protected from unreasonable searches and seizures in the Fourth Amendment itself, which talks about persons, houses, papers, and effects. They couldn't have thought about wiretapping, and they certainly couldn't have thought about cell phone data either. But the law and the protections of the Fourth Amendment have been expanding, over the years, over the centuries, really, far beyond just those limited categories of things. So maybe you could just walk us through a little bit generally as to before we even get to something as modern as cell phone location data, how the court has expanded the protections from that limited list of things.
So what happened is the really important case here is the Katz case from 1967. And in Katz, the court needed to face the question of whether it was, whether the threshold question is always, does the Fourth Amendment apply, so that we need to look at whether a warrant is required. So those things are often collapsed, but they're two separate questions. Usually a warrant is required. It's the default if the Fourth Amendment applies. But the technical question is it a search under the Fourth Amendment? And so the question was, is it a search under the Fourth Amendment when law enforcement agents, but in that case, bugged a telephone booth and grabbed the contents of his communications, a guy who was transmitting wagering information, Mr. Katz. And the question was presented to the court as, did law enforcement commit a physical trespass into the phone booth? Because at that time, the court was locked into this property-based view that you had to violate the security of, an effect or a house or a person in order to trigger Fourth Amendment protection. And the Supreme Court said,
because it's not even a search otherwise, right?
Because it's not a search otherwise. And the Supreme Court said, you know what, we have to recognize that the Fourth Amendment protects people, not places. And we should stop being locked into this narrow sort of view that you have to have a property intrusion. And so but then the question is, so what is protected? What's the test going to be? And it was very difficult for the court to come up with something, because, they said, well, some things that you transmit out in public can still be protected, but on the other hand, not everything is going to be protected. So what is it? And so in a concurrence by Justice Harlan and Katz, he came up with the reasonable expectation of privacy test that said that if you actually expect something to be private, and that expectation is one that society is prepared to recognize as reasonable, then the Fourth Amendment applies. And if you think about that test, it seems, reasonable, it seems intuitive, but it's fairly amorphous. And it has been a test that has made the justices and judges since feel a bit at sea. And so flash forward, and then I can go back, but flash forward to 2012 in the Jones decision, which involved GPS tracking of a car. They put a GPS device onto a car. At that time, 5 justices in the majority decision said, you know what, we don't even have to get to reasonable expectation of privacy here, because we're going to go back and recognize this as a property violation. Because by putting the GPS device on the car, law enforcement, without a warrant, well, actually, warrant in a second, but by putting that device on the car, law enforcement committed a trespass to, in effect, the car, and that was a search under the Fourth Amendment. And so they reinvigorated this property approach that people thought had died in 1967.
So these are all examples, these are all situations where the government in some way is trying to get evidence in a criminal investigation. And the question is, what process does the government have to do before they can just obtain that information from a person? In the old days, in the colonial times, could British soldiers just walk into your house and rummage through your things? Yeah, and they did, and that's part of what led to the Fourth Amendment. And all of these examples then are potentially cured if the government goes and gets a warrant, which they would have to have a probable cause to get, right? They have to have a probable cause for believing that there's a crime committed to get that evidence. And these are all examples where they didn't do that, where the government just conducted some surveillance or obtained some information without going through that step, right?
Right. Yeah, it's very good context. The question is, the Fourth Amendment regulates investigative methods by law enforcement or other government agents, and says, and when the Fourth Amendment applies to that investigative method, the government agent has to present the evidence to a judge and present and establish probable cause, which means, basically good reason to think the person who they're targeting is involved in criminal activity, will be or has been, and the judge has to agree that that's been established before the investigative method can be used. And that's a way of protecting our security, so that police can't just investigate crimes by demanding to see into everybody's homes or into everyone's backpacks, just because that would be a very efficient way to investigate crimes, but it would mean that we live in a police state with no security. So it's a way of regulating police activity by saying you can only conduct these sort of intrusive methods when the judicial officer has intervened and said you have a good reason to do it. And there are other things that go along with Fourth Amendment regulation, like notice to the target. You have to present what you found to the judge, usually afterwards, and then there's a suppression remedy where if the evidence was gathered in violation of Fourth Amendment rights, it should be excluded from the from the trial. But there's a tremendous number of exceptions to that.
So you already, you anticipated one of the general threshold questions I wanted to get out in the first place before diving into the specifics of this case, because I think probably a lot of people don't appreciate, maybe don't even think much about the Fourth Amendment and why it's so important and why it's part of the Bill of Rights, and what it means to have this tension between privacy on the one hand, individual privacy, and of course the important function the government has to make good on, which is to investigate and prosecute crime. So how, I guess with that in mind, we should get into the facts of this case and see how this tension between personal privacy, right to privacy, and limiting government power play out in this specific case. So how does this case present, this Carpenter case?
Right, and I just, before I get into it, I just want to mention a few things. One is that a common misperception is that Fourth Amendment regulation means that the government cannot use the method, which just couldn't be further from the truth. Government can use the method, they just have to follow certain procedures. And what the Fourth Amendment does is set a constitutional floor, which says there must be this warrant based on probable cause, usually. And then Congress is free to regulate above that and add more restrictions or regulations. When that Fourth Amendment floor is not present, Congress is free to set any limits they want or no limits on the method. And then one more thing is, even if there is this warrant requirement under the Fourth Amendment always has an exception for, basically emergencies. So if there's, a kidnap, and the court talks about this in the case, but it's always present if there's an emergency or a kidnapping, some reason for law enforcement officers to act without getting a warrant, they can always do that and then get the process later. And so just that sort of sometimes these horror stories are brought in like, oh my God, if you have to get a warrant, people are going to die. And that's kind of, those exceptions are built into the doctrine that would never happen.
Well, and the other category of exception that, or not, maybe not exception, but different set of requirements is also sometimes brought up, and we talk about this a lot now in sort of a post 9/11 era when there's an issue of national security. Say you need to get certain evidence about an impending terrorist attack, or just about somebody suspected of terrorist activities, and we have procedural requirements to deal with that situation too. But none of that is present in this case, which is in many senses just kind of an ordinary criminal investigation into a kind of a run-of-the-mill robbery case, right? So what is this case about?
It's a serious set of armed robberies that Carpenter was convicted of and sentenced to many, many months, I think, many, many years in prison. And kind of ironically, the robberies were of cell phone stores.
Right.
And what happened is, in the course of that investigation, law enforcement agents compelled his cell phone service providers. So it was T-Mobile and one other provider to provide 127 days of cell phone location data. And so that data indicated, at the time, it indicated the cell phone tower that was nearest to his phone when he made and received calls for the stop and start of those calls. And and it actually was a tremendous amount of data because he was making a lot of calls. So it was, I think, about 100 points of data. I don't have it in front of me, but it was at least 100 points of data a day. And so if you think about it, all that data can really tell you a lot about where a person is and what their habits are and what their associations are, particularly when you associate that data with other information. But for this
criminal investigation, it was also the time of day. So if he was making or receiving a call at a particular time when a crime was known to have happened, that would be pretty strong evidence that would put him at the location of the crime.
Right, and that's exactly what happened. An expert came in and testified that he was using his phone from a location near the robbery sites at exactly the time of the robberies in a couple of cases, and the prosecution referred to that evidence in their closing argument, and so it was, important to his conviction. It looks like, although there was a lot of other evidence, and it was 101 data points per day, and it was 127 days from Metro PCS and from Sprint, and so the process that law enforcement used, that the prosecutors used to get this information, was a statutory process under a law that had been passed by Congress in 1986 called the Electronic Communications Privacy Act. And that law did not require a warrant. It required a much easier to satisfy court order. It did not provide for notice at any point to the target. Usually with this kind of information, you need to provide notice later, not at the time. And it did not provide a suppression remedy. And again, if the Fourth Amendment does not apply to this data, Congress could have provided even less protections. They could have provided no court order, just a subpoena. So, so then the constitutional question is, was that enough process, or does the was Congress free to set whatever process they wanted, or no process at all, or does the Fourth Amendment come into play here? That was the constitutional question.
Well, say a little bit more, Suze, about what cell site location information is. That's the technical term for what this data is that's at issue here. And explain a little bit about how this works, because I think that's going to be really important to understand when we get into was this a search, whose data was this, was his own property being, does he have a right to expect privacy as to that data? So we need to understand what this stuff is, first of all.
Okay, so when so just a couple things. One, you can't turn this data off, okay? For the cell phone to work, or you can't turn the collection of it off. For your cell phone to work, it needs to be in radio communication with cell towers. And then the cell towers take the signal and the information communicated from your cell phone and bring it into the switches and the whole phone network and transmit it off wherever it needs to go. So in order for you to send and receive calls, and actually in order for you to do anything on your cell phone, and we all know that we're texting on our cell phones and we're checking our email on our smartphones, and
right.
A huge number of people have smartphones today versus our old flip phones. But anytime you do that, make a call, make a text, access your email, receive calls and texts, your phone has to make contact with the nearest cell tower in order to process that call. And that information of which tower did you make contact with is logged by the cell phone provider, Sprint, Metro PCS, AT&T, Verizon. They log that information. You don't even know this is happening.
Right? You don't even know this is happening. It's just an automatic thing that happens. Your phone's finding a tower to get a signal bouncing around from location to location, where those locations are cell towers to make your phone work. It wouldn't work otherwise.
Yeah, there was a question at trial it was a question for the court as to how voluntary that process is and how much we know that happens. And of course the government said everybody knows this happens, that the information is being transmitted and recorded. You must know it because you look at the bars on your phone and you sort of know when you have a large number of bars and a small number of bars, so you kind of know how strong the signal is, and so and it's voluntary in the sense of you have a choice whether or not to use a phone. And the Carpenter's lawyer said, more what you're saying, Aaron, which is you don't know about all these details that, how often the information is stored, the fact that it's this tower information. I'll tell you now, it includes not just these towers that are located all over the place, and include not just the big towers, but what are called femtocells and other kind of cells that could be in buildings because they, especially in high traffic areas. So there are all sorts of newfangled towers that are quite small. It includes the new technology can include the speed of your call, the angle of your call, so make it even easier to get your location down to like a 50-foot area.
Wow.
It certainly includes the sector of the tower, so that it can sort of give you a sense of which part of the pie you're in. So a lot of that information is not public knowledge, and the majority accepted that, whereas in other cases where this has come up before in the appellate courts, the courts have said, people know that this information is being collected, and they voluntarily share it by virtue of the fact that they use a phone. And the court here said, no, we don't accept that argument.
Okay, so this data is, and it's also important to, I think, explain what cell phone companies do with this data, because this also goes to the voluntary issue, and it goes, I think, also to whose data it is. We need this, but I know only in the most general sense that I need to be communicating somehow, or my phone needs to communicate with a cell phone tower to get a signal so that we can have this conversation. But the cell phone companies obviously know this, and they collect this data and use this data routinely on every single cell phone. In fact, the court notes, I think, in the beginning of its opinion, that there are more cell phones than there are people in the population of our country. So this is every one of us is having this data obtained by our cell phone company providers all the time. And so explain that. What do cell phone companies do with this data, and why do they collect this information?
Well, let me start out by saying, I've been working in this area for many years, and I was fortunate enough to be able to argue as an amicus friend of the court in 2 federal appellate cases in which this issue was presented, including in 2008 in the Third Circuit in Philadelphia, which is an argument you attended, and then a couple of years later in the Fifth Circuit in New Orleans. And the cell phone company, I asked, my research assistant librarian asked the cell phone companies, cell phone providers to tell us, both what were they storing and what were they doing with the data, and they were not forthcoming. So this is not something this information has not been easy to obtain. And in fact, in the Fifth Circuit case, one cell phone company provided a page that looked like a set of cell phone records, but wouldn't say that was the same set of records that they had provided in the case at hand, and it wasn't dated and it wasn't labeled. So it hasn't been easy to find out, either what was recorded or what was delivered. And interestingly, again, in prior cases in which the lower courts have not recognized a Fourth Amendment interest, they've accepted the cell phone providers' arguments that they don't really store very much of this data, that they only store information for the start and the stop of calls and nothing else, and that they don't have but that they do store information, location information, for example, to sort of figure out where they need to add cells, or so sort of to hone their network, and perhaps to deal with roaming charges. But the Supreme Court in this case said, look, whether or not back in 2011 when the data was acquired, cell phone companies were only recording information at the beginning and end of calls, now it seems that they are collecting the information I mentioned earlier, which is information also when texts are sent and when emails are checked. And even if they're not doing that right now, they're going to be doing it in the future. So it's really interesting to see that the Supreme Court was willing, and partly because of the reason you quoted at the beginning of the Justice Brandeis quote, willing to think about not only the technology today, but where it's going. And certainly not only the technology at the time that the information was gathered, which was, 7 years ago by now.
And I don't know if this is really especially relevant to this particular case now, but it may become relevant, as you're saying, to future cases. The cell phone companies, and this is also something noted in the majority opinion in this case, they're selling data. They're not only collecting this in the normal course of business and perhaps validly to find ways to improve their business, to improve their service, and our access to their service, but they're also selling this data. And there's lots of people out there, lots of companies that want to get access to this data. And we may not know, just like we didn't know, maybe we should have, but maybe we didn't think much about the fact that Facebook sells all kinds of data about users on that platform. So this is something that, whether we know about it or not, it's big business, it's big use of data that's out there that it may not have our name attached to it, but it is our information, or it's information about us. And I don't know if that plays into this case or not, but I would think that that's something that could become very important in future disputes.
Well, just to say two things about that. First of all, there is a regulation of this data called the Wireless Communication and Public Safety Act, and it's 47 U.S.C. 222, that specifically protects call location information and says that that it shall not be shared with other people without the express prior authorization of the customer. And so I don't know. My sense is that this cell site location information is treated differently in terms of commercial sales. And in fact, that statute was something that Justice Gorsuch, in his dissent, thought should be considered to give a property interest in this data. And I think it's actually an additional reason to find constitutional protection here. Unfortunately, that argument was not developed much before the Supreme Court case, and it wasn't developed, I think, at trial. But I do think the cell site location data, again, has been given special solicitation by Congress, and you could say that that is a kind of a property interest in the data. But in terms of providing this information to the government, we have a lot of evidence to show that that the companies are making a business out of it. And in fact, several years ago, we found out that I think it was Sprint had a website specially designed to automate requests for this data. And Senator Markey asked the providers how much of this kind of information and related information they were providing, and it was millions of records a year to the government. And those requests have only increased a lot lately. So when you're talking about, information to the government under this prior statute, that's much easier to satisfy than the Fourth Amendment. Providers were charging for that information to the government and providing huge amounts of it.
Okay, so this guy, Carpenter, is involved in this series of robberies, you say, ironically. I think we're also involved in some Radio Shack stores. Those stores even still exist. And I think it was some T-Mobile stores. And the government, without getting any warrant, would have a probable cause, gets access to this cell site location data. They ask for it from the companies, and the companies provide it. And they make good use of it. They convicted Carpenter at trial and sentenced him, I think it was 100 years in prison for these robberies. So lay out for us then how this lays out as a Fourth Amendment case. What is the dispute that the court has to resolve now that we understand a bit more about this technology?
Well, going back to Katz, then the question that the majority looks at, the five justices, the four liberal justices and Justice Roberts, is, was there a reasonable expectation of privacy in this data using the Katz approach? And to get there, the majority draws a line from the Jones case, which looked at, again, GPS data gathered in real time through a device, and said, that case recognized that location data, again, is very, very revealing because it can tell you about someone's habits, their activities, their political interests, their religious interests, their health. Are they going to an abortion clinic? Are they going to AA? Where are they having their religious practices? And who are their associates? Which, of course, implicates the First Amendment concerns. And also the court in the Riley case, which had to do with the protection of the contents of cell phone data, and in that case, which was, I think, 2014, rejected the application of the search incident to arrest exception to that data. The court also recognized how incredibly full of information cell phones were, and the fact that they're sort of different from traditional things that you would carry in your pocket. And so the court said that, this cell site location data is very similar and very intrusive. And so then the question was, is there a reason not to protect it? Are there ways in which it is different from GPS location data and the contents of cell phones? And that's where the court had to confront the government's third-party doctrine cases, that's the third-party doctrine is the basis of which all the lower courts had, except for a few, but most of the lower courts had rejected constitutional protection here.
So before we get into the whole third-party doctrine, I just want to note, I brought up this quote from Justice Brandeis at the beginning, and you pointed out that that was a case involving wiretapping of a phone call. And the idea from that case, which was, I guess, almost 100 years ago, that questioned what our expectation, what reasonable right to privacy do we have a right to expect in a phone call? Maybe no different than if we're walking down the street and we're observed walking down the street. How does the court in 90-some years find that we do have a right to expect privacy as to this data that most of us don't even know exists? Is it because of how revealing this data can be? Is that the difference?
Well, it's a great question, and really, what you're asking is why is there a reasonable expectation of privacy in cell site location data? And and I'll tell you something. So, back to the method. It's a method of analysis that many justices have criticized because it is some have said it's circular. Right, you have a reasonable expectation of privacy in information when society views that expectation as reasonable. Right, so it's reasonable when it's reasonable, and really the analysis boils down to that objective element because defendants are always going to say they expected it to be private. Justice Scalia, before his death, was very critical of the test. Justice Gorsuch, in his dissent, spent a lot of time criticizing the approach. I think it's a good approach. I've written about it in several articles. I think it's really the best choice for handling this kind of question, which is how does the Constitution weigh in on techniques that have not previously been raised and that do not necessarily tie into the text of the Fourth Amendment. What I've written about in my scholarship is that what you see in the cases in which the reasonable expectation of privacy has been adapted or applied to new technologies is that generally the courts look at four factors. Is the method hidden, intrusive, indiscriminate, and continuous? And that's what the court did, in my view, when it found wiretapping and bugging to be a Fourth Amendment search in Katz in a related case at the same year in Berger. That's what I saw the appellate courts doing when they found video surveillance to be protected, and that's what I see in this decision. So, to sum up, I see a very a normative approach where the court says cell site location data should be protected because it should, just because it should. It should be protected just the way email should be protected. Email should be protected because it should, because it's like telephone calls, because that's the kind of society we should be able to live in, because that's what people should be entitled to expect, which is the language that was used in Katz. Mm-hmm. And then if you look at the factors, cell site location data, it produces, as the court says, it's detailed. The data is detailed, encyclopedic, and effortlessly compiled. It's comprehensive. So and one of the things the court cited is that, as you mentioned earlier, this information is compiled about everyone. So it's not, compare it to a traditional search of your home, where where law enforcement just goes into your house and looks for specific things, which even that is a search and requires a warrant. Here, this is a method where all of the information is compiled about everyone. Are we really saying that should be available to law enforcement without the regulation of the Fourth Amendment? So,
right, and that's crucial, because when we say it's protected, that doesn't mean that it's not under any circumstances available to the government. It is, just as long as they go through a Fourth Amendment set of processes and requirements to make sure that they're not conducting an unreasonable search. They're going through the methods that you have to go through to get that information.
And by the way, under the statute, the Electronic Communications Protection Act, that many lower courts and the government believed that they could use instead of the warrant, they were allowed to collect information about people who were not suspected of crimes, but were associated with other people. As long as the information was pertinent to a crime, pertinent to an investigation, relevant and material to an investigation. But if they thought your cell phone had information pertinent to an investigation, but you were not suspected of a crime, they could collect that information. And that's dangerous, particularly today. It opens up the ability to go after data about journalists, to track down sources, to go after the information about people who are going to protest marches and say, well, I thought it was relevant to some kind of investigation. And so, yeah.
And also, I mean, as you pointed out, and also just to have the government, the danger is having the government just freely accessing information about all sorts of people or anybody for any reason. If you don't have to establish probable cause in the first place, what would stop the government from accessing this data anytime it wants to about anyone it wants for any reason? I mean, that seems to be, at the other end of this tension. If you don't have a reasonable expectation of privacy in that information.
Without Fourth Amendment protection, Congress sets the limits. And in fact, there's an interesting article by Professor Davies that says that one of the things the Fourth Amendment was designed to do was rein in a legislature from passing laws that allowed access too easily. So it wasn't just about reining in law enforcement. There wasn't actually an official police presence at that time. It was making sure that the legislature didn't go overboard in authorizing government searches. So and the other thing to say is getting a warrant today is incredibly easy logistically, and it's not that hard substantively. So police can call in warrants now telephonically. It doesn't take days and days. Separate question, wiretap orders are actually much harder to get, and, I think it's an important to consider at probably a different podcast, whether or not these kind of searches should be at that higher level of a wiretap order. But a regular warrant is not hard to get.
That is a great idea. I mean, it shouldn't be that easy to show probable cause, but I don't know as much about this. We'll have to take this up another time. But I think you're right. Is it too easy? And it kind of begs the question why they didn't just get a warrant in this case. But maybe they were lazy. I don't know. Because they didn't have to. Right.
They didn't have to. Right.
Yeah. Okay. All right. So we have. So all right. So now there's this business about third parties and that's really important how the court works through this issue. I think Justice Thomas even says this wasn't a search in his dissent because this wasn't actually Carpenter's data. It was the cell phone company's data. And the Fourth Amendment doesn't protect information if we've given it to somebody else and we get that information from that someone else. So talk a little bit about that and how that plays into analysis.
Okay, so what you just stated was a broad version of the third-party rule. And what makes this decision by the court so significant is that it clarified that broad vision of the third-party rule, broad version, is not actually the law, which is something I've been arguing for many years. So I was very pleased.
Yeah.
So the third-party rule comes out of cases from 1976 and 1979. And those cases, in one case, involved telephone numbers dialed by a phone and retrieved by a pen register that government used to, again, retrieve just the telephone numbers dialed by a phone. And in another case, the government compelled the disclosure from a bank of records held by the bank on behalf of a bank customer, which was deposit receipts and bank statements and checks, copies of checks. And so in those two cases, the court said, that the phone subscriber and the bank customer did not have reasonable expectations of privacy in the respective information because is important. There were several factors in each case. In the phone company case, it was because the subscriber knew that the phone company was recording that information. It was because that information was really not at all revealing. Again, it was just phone numbers dialed, not the fact that the call had gone through, not how long the phone had taken, certainly not the location of the caller. In the case of the bank records, the information recorded was negotiable instruments shared with the bank in the ordinary course of business. In other words, when you write a check, you know that the bank's going to read it. They have to figure out who to give the money to. It was not
Right.
confidential communications. So what I've argued for many years, including in the appellate courts, and what the court majority accepted here is those cases address the facts of those cases, and they do not set forth a general statement that any information shared with a third party lacks Fourth Amendment protection. Hugely important.
You have to look
for the
at the
internet.
specifics. Yeah.
Yeah, and so what they said is we've looked at those cases, and we don't think that the holdings from those cases should be extended to this scenario. And because what the government said is, where did we get this information here, the cell site location data? We got it from the, quote, business records, quote, of the cell phone service providers, therefore it was unprotected. And the court said, no, there's no sort of business. They didn't use these terms, but the implication was there's no sort of general business records rule that says as long as I got the information from a business, it's necessarily unprotected. Of course, it's no. This information was not negotiable instruments shared in the ordinary course. This information was not telephone numbers dialed. And so if you, government, want to extend those cases, you got to show why they applied, and you haven't shown that. And so it puts, yeah.
Well, so why then? Why does this? Because I find it kind of startling, actually, that the government, without a warrant, could just go into the bank and get copies of my canceled checks and see who I was writing checks to. I find it startling that wouldn't be in some way protected, and the government would have to be held to a higher burden. But why in this case does the Supreme Court reject the idea that merely because it's the cell phone companies that are collecting this information? I mean, obviously, Carpenter himself is not collecting this information. Sprint or T-Mobile or whoever is collecting this information. Why is that not handing over information to a third party where you lose your right to privacy in that data?
Because, again, the court doesn't accept that that's a principle of law that has been established, that when you share information, you lose an expectation of privacy in it. And so what the court says are those cases from 1976 and 1979 binding precedents? And they're not. And those cases are distinguishable, and the court spends a certain amount of time distinguishing them. So whereas the bank records were negotiable instruments that were not confidential communications, cell site location data is revealing. It reveals personal information. It's much more like a confidential communication. Whereas in Smith, you had the telephone numbers dialed that didn't reveal very much. Today, you have cell site location data that is, in this case, 101 points a day of where you were, down to a fairly small area, maybe 50 feet, maybe less in 2011, but maybe 50 feet today. And it's just a very different set of information. So, and where in those two cases, the courts in the 70s found you had voluntarily and knowingly shared the information with the employees in the ordinary course. That's not true with cell site location data, as we talked about much earlier. The court didn't think you did voluntarily and knowingly share it. So once the court has broken the link between those cases and this set of facts and said we don't find those cases binding, then the burden is on the government to say, they're not binding, but they're persuasive. And the court says we don't think they are. So now that we're free of those precedents, what's the right answer? And the right answer is reasonable expectation of privacy. And going forward, what's incredibly significant is almost all of the data we create on the internet is stored with third parties. And the government is now out of a tool that they found very powerful to argue that, that once we use the internet, we have no privacy. And now they can't say that anymore. So it's incredibly powerful. And relatedly, and this is something I faced when I worked on the law professor's brief with Patricia Belia in the Warshak case, the government relatedly said, if you're using a subpoena, a request for documents, and you're the government, automatically the only standard of review that applies is relevance. And the court said, and we had argued this at the time and wrote an article about it, why would we skip the reasonable expectation of privacy analysis? Government, if you're requesting records in which someone has a reasonable expectation of privacy, whether those records are stored with you, the person, or stored with someone else, like your cell phone service provider, we have to apply the Fourth Amendment analysis that may require.
Right. I mean, relevance is a very low standard. I mean, a lot of things could be relevant, but once the Fourth Amendment is involved, then you have all these other concerns that we have to worry about.
Well,
so,
what government was arguing is even if the Fourth Amendment does apply, because, and it's so circular, and if you look at it, it makes no sense, but they argued it vehemently, and actually some of the dissenting judges accepted it. I think Alito did. If you use a subpoena, then the Fourth Amendment requires only relevance, which is obviously cart before the horse.
Yeah.
But that's how they read the precedents, and that's how they read Miller. And what Patricia Belia and I wrote in the University of Chicago Law Review piece is, if you look very carefully at the precedents, all the cases in which they went straight to relevance for subpoena were cases in which there was no reasonable expectation of privacy. And what Justice Roberts said is, we've never actually addressed a case, but there could be a case, and this is it, in which there is a reasonable expectation of privacy in records stored with someone else. And in that case, we'd have to use reasonable expectation of privacy, Fourth Amendment, warrant analysis. So it's really groundbreaking.
So it sounds like, thinking about the significance of this opinion, not only for what it means in terms of this particular data, cell site location data, but it sounds like we could substitute many, many platforms that people use all the time, every day, and that get access to all kinds of information about us. I mean, I mentioned Facebook earlier, internet searches, other things of that nature. There's all kinds of data that goes along with that. Would you expect this ruling to be significant to how those types of disputes would be resolved, and what types of hurdles the government would be required to get over to get access to that type of information?
I think we're going to see a lot of litigation here by defense lawyers, and I think the government's going to have to look very carefully at a lot of their practices. But anything that's detailed, encyclopedic, effortlessly compiled, and I would argue, that could be characterized as, hidden. In other words, we don't know a lot about it, intrusive, gathering up revealing information, indiscriminate, gathering a lot more information that is not incriminating than is necessary, and continuous, so builds up a profile over time, that's going to be subject to the Fourth Amendment. Want to make one more plug, which is in California, we already have a statute that covers all of this. The Cal ECFA statute requires a warrant for access to a whole host of information, including location data and even metadata, including telephone numbers dialed. So California is ahead of the curve on this.
Well, I have to ask you, Dean Freiwald.
First time you told me that.
Right. I know you like that. We're recording this episode the day after Justice Kennedy has announced his retirement from the Supreme Court. And there's all kinds of discussion, and we'll talk about this on future episodes of this podcast too. The significance of his retirement and what this may bode for the court and other issues, whether it's Roe v. Wade and same-sex marriage and things like that. It's very important issues. Justice Kennedy wrote the main dissent in this case, in the Carpenter case, So maybe unfair to throw this at you, but if you could play a little bit of Supreme Court politics, just looking at the makeup, and this is always kind of interesting to do, but as you pointed out, you have the four traditionally liberal justices joined by Chief Justice Roberts to make the majority, and then you have Kennedy writing the main dissent, and then Gorsuch writing his own dissent. What does that tell you, if anything much, about where this whole issue of privacy versus the government's powers and limits on those powers? What does the makeup of this decision, this 5-4 decision, suggest about that?
Well, as you say, none of the Justice Kennedy was not in the majority here, and the other one who was actually, I think, supportive of the result was Gorsuch. I think Justice Gorsuch could have been a concurrence, except that he did have reservations about the reasonable expectation and privacy approach. But I think he thought finding the method to be a search was the right answer. So I think the loss of Justice Kennedy will be felt extremely strongly in other areas, in which he's provided the swing vote. Mm-hmm. In terms of privacy, if you look at how the courts come out, it's Justice Roberts who wrote the Riley versus California decision, or it might be California versus Riley, but the one involving the cell site, Riley versus California, involving cell sites. Justice Scalia was the one who has been a big proponent of modern privacy. The decisions earlier decisions have had almost unanimous votes. And the cell phone Riley decision on the contents of cell phones had, I think, either unanimous or close to unanimous results. So I think the Kennedy loss is going to be less dramatic for these kind of privacy cases than for cases involving other kinds of civil rights, abortion and religion and sexuality law and the like. But I do think we would have hoped for a stronger majority than the 5-4 here. And I think in general, I taught criminal procedure for several years, and conservative justices tend to be much more ready to accept the government's argument, to accept deference to government power, and so you can never rely on any one result persisting.
Well, it is always hard to think that somebody who was convicted of an important crime would not serve time or not be punished for that crime. But the broader issue here is making sure that we don't have unchecked government power. I mean, none of us, if we really thought of it that way, none of us, I think, would choose to live in a society like that. So that's why I was wondering if, in that it was a 5-4 decision, is that even though there's a win, so to speak, for privacy, and I know that you're very pleased with the result, but is there concern as the court may become more conservative in the future, whether that balance between privacy and limiting government power could shift? Well,
and I think the other cases that have come out this week, show that even without the loss of Kennedy, the Supreme Court is very prepared to accord tremendous weight to the executive branch's decisions, and which has very negative effects on our democracy, is my personal view. In terms of privacy, I think the concern for the dissenters really had to do with the things we were talking about at the very end of our podcast, which is about the possible ramifications for subpoena law and the third-party rule, ways in which this decision could have much broader ramifications for investigations generally. I think that's where the concern came in. Rather, it's interesting because with the other cases, that I think the justices have come on in support of privacy because they could easily imagine themselves the subject of GPS searching or GPS tracking or having the contents of their cell phones revealed. So, I think as long as the cases seem, I mean, I don't mean it to sound disrespectful, but if it's new technology and the Supreme Court could imagine themselves being the subject to it, I think we're probably going to do okay.
Well, Susan Freiwald, Dean Susan Freiwald, Sister Susan Freiwald, thank you very, very much for being on Good Law, Bad Law. I really appreciate it. And from the many miles that separate us, it was great to talk with you.
Well, thank you for your excellent questions. It was a great conversation.